In my previous role, I was a criminal attorney at Legal Aid South Africa. I then joined the South African Human Rights Commission in 2010. I started off as a legal officer and worked my way to my current position as the Gauteng provincial head. The nature of my job involves litigation, investigations, and utilization of ADR, or alternative dispute resolution mechanisms, to resolve human rights violations or allegations of human rights violations. Well, I have vast experience in litigation, particularly in the public interest litigation sector. I'm well versed with the intricacies of constitutional and administrative law, but what I lacked was other skills which would make me fully equipped to meet the changing demands for the services of the South African Human Rights Commission. In my view, the age at the time, the age of the new lawyer had arisen, which required lawyers who are aptly suited to resolving disputes using other mechanisms other than litigation. And I saw this as an opportunity to, in furtherance of the Commission's mandate, to equip myself with the necessary skills which will assist me in resolving human rights abuses, human rights disputes, and in building a culture of human rights, in embedding a culture of human rights. And also, this was partly motivated by what is contained in the preamble of the Constitution, which enjoins diverse people to unite. And the Commission is perfectly placed to play that role of nation building, of mutual and peaceful coexistence among the different groups in South Africa. And we saw this as an opportunity to advance the work that we had been doing as the Commission in realizing human rights. And if one looks at the South African Human Rights Commission Act, it does permit the Commission to resolve disputes through mediation, negotiation, and conciliation. And this mechanism of resolving complaints is one of the most underutilized. And the Commission deemed it fit and appropriate to consider this opportunity, training opportunity, to assist in its discharge of its constitutional mandate. And I was part of this cohort of young lawyers who were chosen to participate in this training opportunity, which has assisted me in discharging my work in conflict management, dispute resolution, and it has helped me to understand my role as a mediator. It has helped me to manage mediation from inception to finalization. And it has also empowered the Commission to participate in matters that we wouldn't ordinarily be involved in. There are a number of high-profile cases that we were involved in. The Commission is an active player in the Equality Court. We do litigate on our own or on behalf of complainants or members of the public. And the presiding officers in the Equality Courts have the discretion of advising parties to consider mediation as an option. And I've used all the skills that I have learned to mediate a number of disputes. Two cases come to mind. The first being the matter that involved Mr. Angelo Alcrisi. We successfully mediated the dispute. The second one is the matter involving Mr. Adam Katsavelos. We also, on the instruction of the Equality Court, were able to mediate the dispute successfully. And there are a number of other interventions where we've been involved in mediating disputes, because we understand the important role and the vital function that the Commission plays in our society in strengthening our democracy, as we are located between citizens on the one hand and government on the other hand, or even non-state actors, because the Bill of Rights also applies to private entities. And the Companies Act requires companies to also promote compliance with the Bill of Rights in their business operations. Some of the key skills that one has used to resolve some of these complex matters, the key one is communication. Effectively communicating with parties. Establishing rapport with the parties is very important, and it starts with your body language, and it's also has to do to some extent with what you say during the session with the parties. And communication also helps in creating an atmosphere where there is equalization. And that is why I like mediation, in that parties are mainly driven by their interests. Parties do not generally want to assert their legal rights. They are mostly interest-driven. And I've been able to use negotiation skills. I've been able to use communication skills. I've been able to use my intuition in some of these matters to turn contention into reconciliation. Understood why it is important to remain neutral and to keep the process confidential, as confidentiality is one of the key components to any mediated process.